Crypto Twitter is awash with the rumor of SEC Chairman Gary Gensler resigning from the regulatory agency. Pro-XRP attorney John Deaton commented on the rumors, saying a Gensler deciphering the timing and rationale of the appeal. David Schwartz, Ripple Labs tech master, provided light on the next twist in the ongoing legal fight between Ripple Labs and the United States Securities and Exchange Commission, SEC, in a recent post on X, the site previously known as Twitter. Schwartz's discoveries come at an important time, as they serve to clarify the reasoning for the SEC's latest appeal. According to Schwartz, the crux of the SEC's approach hinges on the Commission's belief that the case hasn't reached its conclusion. According to this viewpoint, parties have the right to file appeals after the matter has been resolved. Such an approach is mainly intended to streamline the legal process, ensuring that the main proceedings are not constantly interrupted by several appeals on supplementary rulings. The appeal arose after Judge Annalisa Torres's important July 13 decision, which defined XRP as a currency rather than a securities, particularly when traded on digital currency exchanges. While the decision favored Ripple, the SEC's following appeal focused on a previously unknown aspect of the legal procedures: concurrent appeals. A catch. 22 Schwartz highlights the need of pooling appeals, arguing that isolated, disconnected appeals may unduly lengthen the court process. However, the current situation presents a more sophisticated difficulty. The SEC believes that some unique circumstances in this instance merit a variation from the regular operating procedure. They suggest that the main proceedings be halted until the appeal is resolved. In response, Ripple's belief stays firm. Even if an appeal is in the works, the core case should continue. This perspective is consistent with the wider judicial tendency of pursuing the main trial and resolving appeals holistically after the major case is resolved. Among these procedural complexities, Schwartz felt it was critical to dispel rumors circulating within the Bitcoin community. Rumors suggested that the SEC was considering elevating Judge Torres's judgment to higher judicial forums. As the courtroom drama develops, the eventual judgment on the admissibility of the appeal might have a significant impact on the dynamics of Ripple Labs' continuing dispute with the SEC. Linda Jones, a well-known Wall Street veteran, predicts a big rush of institutional money ready to join the XRP market, although the timing remains undetermined. Due to the continuing legal struggle between Ripple Labs and the U.S. Securities and Exchange Commission, SEC, XRP has been a recurring issue among experts, drawing significant interest in 2023. The essence of the issue is the SEC's claim that XRP sales, both primary and secondary, qualify as investment contracts, implying that XRP should be classed as a security. If this accusation is shown to be accurate, Ripple might be accused of executing an unregistered securities offering for more than $1 billion. Furthermore, XRP would be subject to SEC regulatory scrutiny. Numerous experts and XRP supporters say that the long-running legal fight has considerably lowered the token's price. However, Linda Jones believes that institutions would eventually drive XRP's value higher if greater legal clarification is supplied. Although Judge Annalisa Torres recently ruled in Ripple's favor, declaring that secondary XRP purchases do not constitute investment contracts, the legal procedures are far from over. Jones emphasizes the role that congressional legislation would have in raising the price of XRP. In my opinion, institutional money will drive XRP's price higher, Jones says. Legal clarity and structure are required for institutions. One crucial component was the litigation. More congressional legislation is required, but it will be passed. The money will then pour in a massive wave. They're getting ready. While the current legal battle between Ripple and the SEC has brought some early respite for XRP, the final outcome and market direction will be determined by future legal developments. The involvement of institutions and the passage of congressional legislation to provide a clearer legal framework are believed to be critical in unlocking the potential of XRP and drawing significant investment into the digital currency. As the market waits for clarification on XRP's regulatory status, focus shifts to the acts of institutions and politicians whose choices will influence the future of Ripple's asset and possibly release a tsunami of wealth into the XRP ecosystem. According to the SEC complaint, Ripple Labs generated more than $1 billion via the sale of unregistered securities. According to the SEC, XRP is a security since it was marketed by Ripple as an investment contract, which is a sort of financial instrument that allows investors to benefit from the efforts of others. The action filed by the SEC is based on the Howey test, a four-part examination used to evaluate whether a financial item is a security. The following questions are asked on the Howey test. According to the SEC, XRP fulfills all four sections of the Howey test. According to the SEC, XRP investors place their money at risk in the hope of profiting from the efforts of Ripple Labs and other third parties. The SEC further claims that XRP is a common enterprise since it is used to enable Ripple network transactions. The rapidly developing cryptocurrency market is rife with speculation and predictions. Ripple's CEO, Brad Garlinghouse, is a well-known figure in the cryptocurrency industry, so when he speaks, people listen. According to Garlinghouse, XRP is on par with Bitcoin and, in fact, XRP is the next Bitcoin. More ambitiously, Garlinghouse set a goal price of $10,000 for the digital currency as part of his XRP vision. Considering XRP's current market valuation and the amount of money that would need to flow into it, this figure may appear impossible to some, but the Ripple CEO quickly reacted, saying that market cap has no bearing on currency value. This comment challenges conventional wisdom and raises some fascinating questions about how we judge cryptocurrency. Those familiar with the history of XRP and Ripple's bigger plans may not be surprised by Garlinghouse's optimistic assessment of the digital currency's future. Ripple has made it clear that it believes XRP will play an important role in international trade, money transfers, and global payment systems. To further prove XRP's practicality and use, the company has signed partnerships with several financial institutions across the world. Garlinghouse isn't only praising XRP as a possible Bitcoin alternative with a high growth rate and price. Instead, he is suggesting that XRP's utility and widespread adoption might rival or even surpass Bitcoin. In this imagined future, XRP is not just another cryptocurrency, but rather an integral part of the global financial system. The legal battle between the U.S. Securities and Exchange Commission, SEC, and Ripple Labs continues to develop. After initial objection by Ripple because of the law firm's connection to the SEC, Judge Lisa Torres has now approved the inclusion of an investment banker declarant. The SEC has approved Andrew A. Kunsak of the prestigious law firm Sidley Austin LP to represent the agency in the ongoing case against Ripple Labs. In previous court order had sealed certain documents, and the paper claims that Kunsek's involvement is meant to ensure that no hidden facts get out. Both the SEC's motion about the Hinman speech documents and Ripple's motion concerning its XRP sales income are related to this. Cases like this generally involve sensitive company or shareholder data, given the murky nature of blockchain in the crypto world. Given the SEC's intention to appeal a recent ruling by Judge Torres, the court's move seems to be a cautious attempt to safeguard such information. The SEC has taken an unusual step by seeking an interlocutory appeal. Their argument is that Judge Torres was wrong to rule that program sales of XRP do not qualify as securities under the venerable Howey test. The distinction between regular digital assets and those that may be considered investment contracts, the latter of which are subject to harsher rules, is highlighted by this distinction. The SEC's current objective, according to Ripple's chief legal officer Stuart Alderoty, is to secure a court order to file an appeal. They are not formally contesting the decision to treat XRP as a security despite widespread perception otherwise.